everybody. Welcome back to dinanddaf. This is Elana Stein Hain, and we are here to learn about Dina Dmlchutא Dina, the law of the sovereignty or monarchy, or today we say the law of the land is law. It is a principle that comes to us originally in Bava Kama, but we saw it again this week in Bava Batra, Daf Nun Dalet Amud Bet to Nun Hamid Aleph, and it comes from Shmuel. Now it's interesting. I saw that I don't remember who pointed this out, but the fact maybe Shmuel Shiloh was like a Mishpat Ivri professor, somebody who looked into the parallels between legal theory, secular legal theory, and jurisprudence, and halachic thinking, and Chazal. So I think he pointed out it's interesting to note that, of course, Shmuel, an early Babylonian Amora, is the person who comes up with this concept because you really wouldn't expect that from, first of all, you wouldn't expect it from Amorei Eretz Israel, and you wouldn't expect it from the Tanaim living in Eretz Israel because the Malchut under which they were living, Rome, was first of all considered an intruder, a foreign entity intruding on Jewish sovereignty. And second of all, even the seat of power of Rome was not in the land of Israel, it was in Rome. Right. So I think that was just an interesting point that he made. And what I want to do is I want to spend a few minutes thinking about the logic behind Dina Dmlchutã Dina and its parameters. All right, we're not going to do everything, but we're going to give ourselves a nice big overview. So the first question, I'm going to ask three questions about Dina Dmlchutã Dina. The first is, what is the underlying logic of Dina Dmlchutã Dina? The second is, what are the parameters of Dina Dmlchutã Dina, specifically where it is in tension with or competition with Jewish law? And the third question is, does Dina Dmlchutã Dina include things that are unfair dinim, prejudicial dinim, as it were, and really what's considered prejudicial dinim? And we have to remember that the conversation about Dina Dmlchutã Dina, halachically, it develops through many different time periods in Jewish life. So we might ask questions about, does Dina Dmlchutã Dina apply to a Jewish sovereign government in Eretz Israel, for example? But they also might be asking, in medieval Europe, does Dina Dmlchutã Dina apply to a special Jew tax where Jews are being taxed unfairly? Do we say that falls under Dina Dmlchutã Dina? So it's sort of a prism through which to experience Jewish life and the changes in Jewish life over time. So I'm going to start us off with two different approaches to the logic behind Dina Dmlchutã Dina, and for that we are going to go to our Rishonim. One sec. Sharing my screen. Here we go. So first we're going to look at the Ran, Rabbeinu Nisim, from 15th century Spain. And I do think it's interesting to note where people are from and when, because you start thinking about what kind of governments they lived under and how a conversation about following the local secular law or the local government is relevant and sort of has different dimensions to it. So the Ran says, the Tosfot wrote, Dafka b'malchei ovdei kochavim amar de Dina Dmlchutã Dina. Right? We only say that Dina Dmlchutã Dina applies regarding Gentile kings, or I would say regarding secular non-Jewish governments. Why? Mipnei shehaaretz shelo, right? But this is very monarchic, right? Because the land belongs to the sovereign. V'yachol amar lahem, and the sovereign can say, Im lo tasu mitzvotai. It sounds very biblical, like L'havdil Hashem talking to the Jewish people. If you don't do my mitzvot, agaresh etchem min haaretz. I am going to expel you from the land. Aval b'malchei Yisrael, but when it comes to Jewish kings, lo, Dina Dmlchutã Dina doesn't apply. Lefi she'eretz Yisrael kol Yisrael shutafin ba. because all of the Jewish people are part owners of Eretz Yisrael, right? So here we have sort of a 2-for-1. Number one, we have, and I gave you Rabbeinu Nissim because he just says it very clearly, even though he's quoting Tosfot. Number one, the reason behind Dinah Dmalchutא Dinah is because the non-Jewish sovereign is in charge. It's actually a matter of somebody else owns the space. You have to follow what they say. They have a right to kick you out if you don't follow what they say, which, as I mentioned, it's actually very similar to the way we think about God's relationship to the Jewish people and the land of Israel. I kick you out if you don't follow what I say, right? And the second piece that we get is, here's an nafka here's a practical distinction, because Eretz Yisrael, all the Jewish people are shareholders in it. So it wouldn't apply to a Jewish king in Eretz Yisrael. So very monarchic reason. It's about ownership. It's about being able to be kicked out. I want to mention, and I think this is really fascinating to think about. First of all, they can't envision another kind of, or they're not envisioning another kind of government where it's not a king who owns everything, but it's a democracy, let's say. And second of all, they can't envision a Jewish king of a non-Jewish country, right? It's very interesting just looking at, a Jew who was just elected the president of Mexico recently, looking at all the Jews who are involved in some way or another close to government in the United States. It's just fascinating to think about. So that's the Ran. That's really the Balei HaTosfot. And let's not talk about the implications for people paying their taxes in Eretz Yisrael today, because that's a very sad state when people actually try to rely on the Ran not to pay their taxes. Okay, let's move to the Rashbam. Right, we're going a little bit back in time, 12th century France. And even though we're going back in time, although the Ran was quoting the Balei HaTosfot, so we're not going so far back in time, the Rashbam actually has much more of a social contract theory, right? It's actually less about who owns the land and is going to kick you out, and it's more, we all agree to be here under this government. Kol misim v'arnoniot u'minhagot shemishpatei melachim, all taxes and practices of the laws of the kings, sheregilim lanhig b'malchutam, that they are generally accustomed to lead in their sovereignties, in their I don't know, kingdoms. I don't know where my brain. Dinahu, that's the din, that's the law. Shakol b'nei malchut mekablim aleim mirtzonam chukei hamelech u'mishpatav. Because everybody who lives under that sovereignty accepts upon themselves from their free will, meaning by virtue of deciding to live there, they all accept upon themselves the law of the king, right? This is a social contract theory in practice. Now, you can imagine, obviously, this is going to apply in Eretz Yisrael as well, right? Because it's not about who owns, it's about people agreeing to be bound by something, to be bound by a government, right? And it's interesting, I would say it only gets more strengthened in a democracy, right? The sense that you, plural, actually voted in the government, right? The government represents the people. We're not going to say, okay, if the person you voted for doesn't win, somehow things change. You are part of this virtuous social contract, okay? So those two, I think, just as a beginning, thinking philosophically about Dinah Dmalchutã Dinah, I love how different they are. I think they're very thought-provoking. I think the question of, getting deported is really such a different way of thinking than the question of people agreeing to be bound by something. So that's layer one. What's the logic behind it? Layer two, let's talk about what happens when Dinah Dmalchutã Dinah rubs up against Jewish law, right? So a very famous example is an example that's brought in the Shulchan Aruch, in Choshen Mishpat, Siman Ayin Gimel. In that, in the Seif of Shulchan Aruch, where it describes Seif Yudalid, basically what we're looking at is, according to Jewish law, we say that stam milva shloshim yom, that when I give somebody a halva, I give somebody a loan, they're expected to pay me back within 30 days, unless otherwise stipulated. And the truth is, if I have a mashkon from that person, if I have collateral, after those 30 days, if they don't pay me back and they're not going to pay me back, I can sell off the collateral. But apparently, where this was taking place, the discussion in the Shulchan Aruch, there was a secular law, a non-Jewish law, that you had to wait a full 12 months after the loan was due before selling the mashkon, before selling the collateral. So what do? Do you follow Jewish law and you can sell the collateral after Shloshim Yom? Or do you follow non-Jewish law, dinah dmalchutah, and you can sell the collateral only after a year? So the Ramah, Rav Moshe Isserlis, quotes a Yesh Omrim, a perspective that says you follow secular law, you follow non-Jewish law. The Yesh Omrim, Timamakom, Shahaminhag, Shahamal Vela'akum, where the minhag is that if you lend money to a non-Jew, lo yuchal mochro b'pachot mishana, you can't sell it less than a year after the loan came due. Danin gam became gam b'Yisrael. We use the same halakha and apply it to Jews, meaning b'Yisrael shehova lechavero al hamashkon, a Jew that lent money to their fellow on collateral. We follow the minhag of the makom, right? It's interesting that it doesn't use dinah dmalchutah dinah. The terminology that's used is not dinah dmalchutah dinah. The terminology that's used is, this is the minhag. Presumably, I'm going to add to it. Presumably, even when these two Jews made this transaction, the expectation was the same way if I were borrowing from a non-Jew, they couldn't sell my collateral for at least 12 months. The same way if I were lending to a non-Jew, they couldn't sell my collateral for at least 12 months. With a Jew, we're going to do the same thing. Now, it's very interesting. I don't really know. I wonder if there's any also business aspect to this, right? In terms of from whom are you going to borrow money, to whom are you going to lend money, right? If Jews are going to collect collateral, sell collateral after only 30 days, and a non-Jew is going to sell collateral after only a year, then maybe you go and you borrow from the non-Jew. Or maybe you'd rather, but I don't know, because on the other hand, you might say, I'd rather lend to a Jew where I can sell the collateral after 30 days than lend to a non-Jew where I can only sell it after 12 months. Or maybe it just doesn't look good for business that you're doing things differently, right? It's just hard to know, is there something behind this that is also concerned with keeping Jews lending to each other, right? And not looking outside to get a loan because it gives them more time. I don't know, right? It's quoting the Mordechai, and it doesn't seem that there's a conversation about that, but it's interesting to consider. But the Shach, the Siftei Kohen, he is not having any of it. Absolutely not. He says, what do you mean? How are we going to learn from the laws of non-Jews to abrogate a Torah law? Now, is it a Torah law that you can collect 30 days after the milva comes due? It's not clear. Chas v'chalila, lo, he says, lo tieh kazot b'Yisrael. We're not doing this. V'lo mi baya lo tana poskim shesovrim d'lo dinah dmalchutah dinah rak b'dvarim shehem la'anat hamelach. He says, first of all, there's a whole class of poskim who say dinah dmalchutah dinah has to be limited, so limited. Only things that benefit the king, only things that benefited the government. V'lo bin ish l'chavero, and not among people. So he says, number one, certainly according to those people, I don't have to say that we're going to keep the 30-day rule. Of course I'm going to keep the 30-day rule. Dinah dmalchutah dinah shouldn't even apply here. This is between Ben Adam Chavero. This has nothing to do with the Melech. It has nothing to do with the government benefiting. But he says, Ela afilu l'shar poskim. But even according to other poskim, tisovrim damrina dinah dmalchutah b'chol davar, who say that we do follow dinah dmalchutah dinah in everything, meaning in other things as well, right? It says, Hainu dafka mashe'eno neged din toratenu. right? That's only when it's referring to things that are not against our Torah, ela she'eno mefurash etzleinu. Rather, things where we have a gap in our law, meaning if halacha doesn't say anything, and we're talking about civil law, and halacha has no rule for it that's explicit, and secular law does have a rule for it that's explicit, we follow secular law. That's it. But he says to use the non-Jewish law against something that's explicitly Jewish law that we sell after 30 days, we can sell the mashkon. Chalila, God forbid. But say came to Israel. For sure, we shouldn't do this. It says absolutely not. God forbid that we would learn to undermine and to contradict our dinim. So it's interesting to see the Ramah is saying, yeah, we're going to follow the minhag. This is what we do. You wait 12 months. And the Shach says, no, this is a site of danger, right? Meaning this is a site of danger where we might be letting in a competing system of law. Dinah Dmalchutah Dinah either has to be restricted only to the things that are for Hana'at HaMelech, that benefit the king or the queen or the government directly, or even if it's a little more expansive than that, we can't do Dinah Dmalchutah where we have an explicit law that says something different. It's only if we have a gap in our law, only if our law doesn't have anything to say on a particular issue, right? So it's a really interesting conversation. Now, I'm not going to say, by the way, the Ramah, it's not like the Ramah thinks so differently. In fact, when you look at the Ramah in Choshen Mishpat, Shin Samech Tet, look at what he says. Lo amrina dina de malchuta, ella b'davar sheyesh lo hana'ala melech. We only say dina de malchuta dina in something that brings some benefit to the king, to the government, to the queen. O shehula takanat b'nei hamedina, or it's for the purpose of doing something significant for the citizenry. It's not like we're supposed to bring into our courts the dinim of Gentile dinim. Dinim can be lu kol dinei Israel, because if so, then you've nullified all of our Jewish civil law. So it's interesting because it's the same Ramah who quotes the Yesh Omrim. It seems like for the Ramah and the Yesh Omrim in our case, it's, we're not talking about adjudicating in a court of law necessarily differently than we would usually use our civil laws. It sounds like we're just saying, okay, follow the minhag of where we are. So it's a tricky thing in this second level of asking ourselves, well, when we say Dinah de Malchutah Dinah, are we really saying Jewish law is incorporating some secular law, right? So when we don't have a law in the books, we'll take that. Again, only in these realms of civil law, right? We're not talking about Gittin and Kiddushin, and right? We're not talking about Dinei Isura at all, right? Only in the Dinei Mamonot realm, right? So do we say that Jewish law can take some secular law in? Or is it sort of like secular law is overriding Jewish law? And the Shach wants to make sure that's not going to happen. And the Ramah wants to make sure that's not going to happen, right? And that's sort of the danger of what happens when you bring in Dinah de Malchutah Dinah, which is kind of interesting. So that's the second layer of what happens when there is a competition between the two legal systems. And again, sort of like a foundation on which to start analyzing lots of different cases that come up. The third thing that I want to do is I want to look at where the laws seem to be unfair. Now, back in Bava Kama, and I love how we say back in Bava Kama because it's like we're in Bava Batra. We live in Bava Batra right now, which is, you'll notice my beautiful karka that has Cheskad Gimel Shanim behind me. You may notice. So here I am in beautiful Bava Batra land. But back in Bava Kama, the place where Shmuel's principle came up was in the context of talking about tax collecting and what tax collecting is fair and what tax collecting is not fair. So the Mishnah in Bava Kama on Kuf Yud Gimel Amud Aleph says, "Ein portin lo mitevat hamochsin v'lo mikis shel gabain," etc., etc. You shouldn't make change from the tax collector's table, meaning there's something wrong with the money collected at the tax collector's table. It's gezel. It's not appropriate. You shouldn't use it. And so the Gemara says, what do you mean? What's the problem with tax collectors? Umochsin, tax collectors. V'ha'amar Shmuel, didn't Shmuel say, Dina Dmlchutא Dina, the law of the land is law, but tax collectors, secular tax collectors, there's nothing wrong with the taxes that they collect or that Jews collect on behalf of the government, whatever it is. So why is there a problem? Rav Chanina bar Kahana, Amar Shmuel. So Rav Chanina bar Kahana says in the name of Shmuel, well, this is actually speaking about a particular tax collection instance, which is b'moches she'ein lo kitzvah, a tax collector that has no limit, meaning there's no transparent amount that people have to pay. They take whatever they want. And you know what that makes them? A gazlan. Not dinah d'malchutא dinah, a gazlan. And by the way, Debei Rav Yanai gives you a different ukimta, a different explanation of what this Mishnah is talking about, the case that the Mishnah is talking about. Amri, they say, b'moches ha'omed me'ilav, a tax collector who decided on their own, was not sent by the government. Like, I'm here collecting taxes. Nope. Gazlan also. Don't go near that money. But the point is, what we see here is Shmuel's halakha of dinah d'malchutא dinah should not apply to things that are unfair, that are themselves should not be legal. And what's an example? A moches she'ein lo kitzvah, a tax collector with no limit on what they're collecting, no set amount that they're supposed to collect. And I think this is very interesting because there certainly were situations where Jews found themselves maybe paying a set amount of taxes, but they were paying more than their neighbors, or they were paying a special Jew tax. So do we consider that to be moches she'ein lo kitzvah, and maybe dinah d'malchutא dinah shouldn't apply? Or do we say, well, it has a kitzvah, it's just a special kitzvah for the Jews, okay? So it's interesting to see that the Maharik in 15th century Italy, in Cologne, he says, V'gam ein lomar d'hacha lo shayach lemimar dinah d'malchutא. I don't think that you can argue that dinah d'malchutא dinah doesn't apply. Kivan she'Yisrael poreh yoter me'hakuti, where a Jew has to pay higher taxes than a non-Jew. Sharei katav Mordechai sham, because the Mordechai wrote, lo amrinan elek she'amelech mashveh midotav, right? Says the law of the land is where the king is mashveh midotav, the king is consistent in the amounts, right? Devadei pshita deshaper mikre mashveh midotav, says this situation, even where the Jews are paying more, is still considered being consistent in the amounts. Kevan shakol yudi poreh b'shaveh davar katsu, because every Jew pays the same amount. So this is just so interesting, right? Like, just to think about where the Jews have been and where dinah d'malchutא dinah was fair and where it was unfair, and how do you determine what's fair and what's unfair, right? Today we would say if there's a special Jew tax, like, what are you talking about? That's absolutely unfair, should be illegal, right? But that doesn't seem to be the case. The Maharik is arguing in 15th century Italy. Now, I compare to that, interestingly, what the Shulchan Aruch in Choshen Mishpat and the Ramah talk about, what happens when there is like a special law particularly to collect money from particular people. Is that considered legal or not? Is it covered under dinah d'malchutא dinah? So let's take a look. V'chol melech sheka'as al achad me'avadav v'shamashav, and any king who gets angry at one of their servants or one of their servants, mibnei hamedina, from those who live in the country, v'lakach sadehu o chatzero, and they took their sadeh, they took their field, they took their yard, eno gezel. That's not considered gezel. Mutar lehanot ba, you can use it. V'alokech me'amelech harei shelo, and if you buy that property from the king, it belongs to ve'ena ba'alim motziim otam yado, and those originally wronged people can't come and say, we're taking it back, right? Interesting, meaning mishpat hamelech, what was considered permissible, we know very early from Nevi'im, right? This is what Shmuel tried to warn the people, you don't want a melech, because of mishpat hamelech, they can take whatever they want. So if they take it, it's taken. אבל מלך שלקח שדה או חצר של אחד בני המדינה. But if the king takes a sadeh or takes a chatzer from somebody in the Medina, shelo b'dinim shechakak, not based on law. I guess they already had written into law that if somebody wrongs the king can, as a penalty, can take something from them, especially within the kingly court. But if there's something where there's no law on the books, hareze gazlan, then the king is a thief. And anyone who buys that possession, the original Baalim can come and say, you bought that fraudulently, give it back. Or it was taken from me fraudulently. Klalo shel davar, here's the general rule. Kol din she'achkok oto hamelech lakol. If the king makes a general rule for everybody, v'lo yeh la'adam achad b'fnei atzmo, and not a specific rule for a particular person, eino gezel, that's not gezel. So apparently, again, there's a general rule. If someone in the court crosses the king can take their stuff. But just to go over and say, anybody who lives in Tucson, Arizona, on this particular street on a Wednesday, we can charge them. That is a problem, right? That's gezel. It's Hamas, right? It's not considered something that is appropriate. It's not law. Okay, interesting. So you shouldn't be able to take from one person randomly. There should be a law in the books. Now the Rama says, what if there's one class of people that has a rule applied to it, which is very similar to the Ma'arik's case of there being a Jew tax, right? So the Rama says, V'im hamelech chakak lebal umanut echad, if the king makes a law regarding one guild, kigon shechakak, or I should say one, I'm going to stick with guild, okay? Kigon shechakak lemal v'beribit is a davar. For example, there's a rule that anybody who lends on usury, lends on interest, right? Maybe there's a particular rule about an amount that they have to give to the government or to the king. Yeshomrim, some say, de lo amrinan be dinah dmlchutא dinah. We don't think dinah dmlchutã dinah should apply according to some, because it's not the same for everybody, right? So this is very interesting. You see that the Ma'arik is willing to say, as long as the king is mashveh midotah for a particular group of people, even if you have to pay a Jew tax, it's still dinah dmlchutã dinah. Whereas the Rama is quoting this Yeshomrim, that if it's not mashveh lakol, meaning mashveh lakol, like it's for everybody, then dinah dmlchutã dinah, maybe they might think should not apply. Now, suffice it to say, there are likely all sorts of really interesting historical experiences that people were going through that inform the way that they're analyzing these situations. And if I could take a time travel experiment to go to these places, not to be subject to the laws there, but to see and observe what's going on, I think it would be utterly fascinating. Thank God we are in a time where what we have to worry about is making sure that people understand that dinah dmlchutã dinah, secular law, should apply in the state of Israel, and we are not in a situation where we're worried about Jew taxes and things of that nature. Although I'm sure for people who work in Batei Din, they can tell you interesting things that still come up in terms of the competition between secular law and Jewish law. Thanks everybody for learning with me. Always a pleasure.